First of all, thank you for your invitation. It's always like for me coming home to Vilnius, so it's fantastic, and the conference as well. Thank you for this. Yeah, is it really dramatic like this? In my overview statement, I noted that the legislature frequently exhibits a greater degree of boldness and flexibility than its addresses. Consequently, it is unsurprising that modifications to established routines of conflict resolution are perceived as disruptive and met with resistance. The mere imposition of novel approaches via legislative force often falls short of achieving the intended objectives and leads to bypassing the actual goals. I have related these statements to the relationship between voluntariness and coercion in mediation. The universal dogma of voluntariness persists in the Austrian mediation community and is also perpetuated in current works to the effect that the idea of voluntary involvement in mediation is an essential prerequisite for the motivation of the mediating parties. If a party was forced into mediation against their will, there would be little reason to engage in the process consistently. However, a possible positive aspect of mandatory mediation could be that the parties would otherwise not even consider the possibility of out-of-court dispute resolution. There are isolated endeavors to introduce compulsory mediation attempts and to expand them depending on developments, but implementation remains to be seen. I consider these statements to be worth scrutinizing for two reasons. Firstly, I think I can already identify a differentiated concept or conception, maybe it's better, conception of voluntariness. Secondly, the European Union and Austrian legislature have long since tweaked several aspects of voluntariness. It is therefore important to scrutinize this and then put the initiative of the legislature in relation to strengthening the use of mediation. Let's look at Australia. Yes, that's right, Australia. Especially the Gold Coast to Lawrence Boulle and Rachel Field. Back in 2018, in their joint work Mediation in Australia, the two of them made it unmistakably clear that voluntariness as a fundamental value of mediation has lost its relevance over the years, or even more directly, its importance for mediation. That is a strong statement. But is it true? Boulle and Field note that mediation, as we understand it today, has been defined as a system based on voluntariness. The claimed voluntary nature of mediation participation was contrasted with mandatory or coercive aspects of litigation in which parties can be compelled to attend and participate, and if they decline to do so, can be forced and comply with court-ordered outcomes. The early emphasis of voluntariness was linked to mediation's alternative character. If mediation was not a voluntary system, it would not constitute a true alternative to litigation. For further considerations, Boulle and Field take the cue from Bobet Wolski, who differentiates between 4 dimensions: entry into mediation, absence of settlement pressure, mutually acceptable outcomes, and the ability to accept or reject particular outcomes. The final three dimensions can be more appropriately and realistically conceptualized as elements of mediation's party self-determination value. Boulle and Field based their observation of the loss of importance of voluntary entry as an essential element of mediation on measures taken by legislature, for example, with order participation in mediation, as we heard before, or make the use of mediation a condition of granting legal aid. Moreover, with the ever-increasing institutionalization of mediation in court system, emerging cultures are elevating mediation to an expected occurrence. Such expectations create a soft mandatory mediation environment. So far, so good. But what trends can be identified from the European legal requirements, and how is the Austrian legislature responding to them? Let's start with the European Code of Conduct for Mediators, which sets out principles mediators can voluntarily and autonomously undertake to observe. The preamble contains a definition of mediation, according to which mediation means any structured process, however named or referred to, whereby two or more parties to a dispute attempt by themselves on a voluntary basis to reach an agreement on the settlement of their disputes with the assistance of a third person. This information is all we can find in our topic here. The European Mediation Directive for cross-border disputes in civil and commercial matters from 2008 seems more interesting because its statements are ambivalent. Recital 10 contains a procedure definition almost identical to the Code of Conduct. According to this, a voluntary process is also to be assumed. In recital 13, it is noted that it is a voluntary process in the sense that the parties are themselves in charge of the process and may organize it as they wish and terminate it at any time. However, it should be possible under national law for the courts to set time limits for a mediation process. Moreover, the courts should be able to draw the parties' attention to the possibility of mediation whenever appropriate. This extended understanding of voluntariness is manifested in Article 3, which indicates a structured process initiated by the parties or suggested or ordered by court or prescribed by the law of a member state. It includes mediation conducted by a judge who is not responsible for any judicial proceeding concerning the dispute in question. It excludes conciliation attempts made by the court, so this court conciliation, as we discussed before, or the judge to settle a dispute concerning the dispute during judicial proceedings. The Mediation Directive, which is aimed at minimum harmonization, does not prohibit further reaching national obligations to use mediation. Therefore, it could be said that the legislature of directive is incentivizing the member states to create compulsory cases. Okay. So wide, so good. Another interesting example on the European Union side is the Platform to Business Regulation from 2019, which in principle maintains the voluntary nature of mediation. However, Article 12 provides that notwithstanding the voluntary nature of mediation online, intermediation services providers and business users must act in good faith in all mediation attempts conducted under this article. A certain originality cannot be denied to this idea coming from the Anglo-Saxon legal sphere. Recital 42 states the following: since the providers of online intermediation services should always be required to identify mediators with whom they are willing to engage and should be obliged to engage in good faith throughout any mediation attempts conducted under this regulation, these obligations should be established in a way that prevents abuse of the mediation systems by business users. We thus recognize differentiated understanding of voluntariness. The voluntary entry as an essential element is also already loosed in the EU. But anyone who believes the Austrian legislature has utilized this initiative unconditionally is mistaken. Over the years, however, a flexible set of voluntary regulations has emerged, which is not unlimited in principle, but in one case is striking. What I mean by this follows immediately. The central Austrian set of rules on mediation is that of the Mediation Act in Civil Matters. Section 1 describes mediation as a procedure based on voluntary entry and the parties' self-determination. Section 17 of the Mediation Act also states that the parties can withdraw their participation in a mediation procedure at any time and without consequences. This act from 2003 is therefore based on the ideological concept of voluntariness. The addition of provisions under civil procedural law also accompanies the creation of the regulation. Section 204, second sentence of the civil procedure rules leads to the understanding that the Austrian court may encourage the parties to a civil dispute to seek amicable solutions outside the court as part of conciliation efforts. This approach is also generally chosen by the legislature in the Non-Contentious Proceeding Act, which is in particular forms the basis for family, child and inheritance matters. Under Section 29, if an amicable settlement between the parties is to be expected, in particular with the support of a suitable institution like a mediator, the court is to stay the proceedings, provided that this does not jeopardize the interests of the party or the general public, the protection of which is the purpose of the proceedings. So this was also 2003. This regulation got a small brother. A small brother in the sense that the influence of the European Mediation Directive brought the section on parental responsibility regarding custody and personal contact with the child. The Austrian legislator, it's yellow now, the Austrian legislator went further 10 years later, so 2013. Under Section 107, the custody court can order the parents concerned to take part in an informative meeting via mediation to safeguard the best interests of the child in the event of disputes regarding custody and the right of contact. So it's not the first session, it's just an information session. It's a step before. From an Austrian perspective, this has undoubtedly broken a small dam and given the voluntary debate a new drive. However, Further example of legislative creativity would remain unmentioned if we were to conclude with these considerations. We are talking about regulations on neighborhood law, genetic engineering, and Disability Employment Act, all of which provide for procedural insertions the general temporary access restrictions to court. All launched in the period from 2003, 2004, and 2008. Finally, the 2008 Vocational Training Act introduces on closer inspection truly difficile, or should we say an unusual form of mediation. Such mediation must always take place if the person entitled to train an apprentice intends to terminate the apprenticeship relationship prematurely. Accordingly, such an extraordinary termination, which is linked to a strict timetable, is only effective after a mediation procedure has been carried out, unless the apprentice refuses to participate in a mediation procedure in writing. Conclusions. Let's sum up 3 bullet points. As Boulle and Field note for Australia, the voluntary nature of entry is no longer sacrosanct for the parties. However, this observation applies not only to Down Under, but to the European Union and its member states. It is therefore no longer possible to speak of dogma in the sense of the indispensability of voluntariness. From the Austrian perspective, the mediation directive is particularly the game changer. Second, even if the voluntary nature of entry has been dropped, further interventions at the level of the right to self-determination can only be observed in exceptional cases. From the Austrian point of view, apprenticeship mediation builds up pressure with regard to both entry into mediation and agreement. So there is no real choice. Third and last point, the coercive regulations fail to reach the actors concerned. Here are 3 examples. A, attempts to reach an agreement in neighborhood conflicts do not take place in mediation, but are initiated, if at all, via conciliation procedures. B, the referral in child custody law to an information meeting about mediation is seen as judicial harassment. There is a lack of positive emphasis. C, the most conspicuous mediation construction in the area of apprentices is bypassed altogether, in that the build-up of pressure on the part of employers leads to an amicable termination of the apprenticeship relationship. Instead, this would be an appropriate field of conflict to place the conception of good faith into discussion about compulsory mediation. To make a long story short, there is nothing against coercive rules in attempting mediation, but coercive systems that open uneven alternative process routes are worthless and damage mediation, especially in Austria. And thank you. Adieu.